Yes, Mr. Sweeting, where are we?
Well, thank you for the additional time. The position is that the appellant would seek an adjournment in order to call further evidence. I think our understanding was what, provisionally at least, the court had in mind was that the matter would remain in this court for that evidence to be received. And there's the issue.
Oh, I see, as opposed to being remitted.
Yes.
No, I think that is what we had in mind.
Yes. And that is the basis on which we would seek an adjournment.
So as not to keep us in suspense and to know what sort of note to take, is the application opposed?
It is, yes.
Right, off you go.
Well, my lord, we would ask for an adjournment to provide further evidence in relation to a number of the suggested ways of dealing with the Robertson-Johnson problem that are canvassed in the judgment, but where the judge has observed that there was no evidence before her. The position at the moment is that there is something of an impasse because two judges at first instance in the High Court have determined that they are bound by Robertson-Johnston for all practical purposes. As the judge in this case at first instance said, that is the end of the matter, and there would be very considerable difficulties in the way of a claimant seeking to adduce expert evidence in relation to the issues surrounding the discount rate, the issues which might otherwise be addressed by an IFA or an expert in relation to mortgage rates at first instance, given the position now. It would be difficult to obtain permission to do that. There would be a very significant risk in relation to an issues-based costs order if at the end of a trial the claimant was simply met by a finding of the sort which has resulted in both of those cases, JR and Sheffield, in this case, that Robertson-Johnston is binding, and therefore the court is simply committed to use the formula which it sets out and thus arrive at a zero figure in relation to the additional costs of special accommodation, which is the issue before this court. Now, I know a moment ago, before the short adjournment that we were allowed, your lordship canvassed the possibility of there being further evidence on the point. Our provisional view is that evidence ought to at least come from an IFA. The question, I think, is whether there should be evidence of a wider sort, and also whether or not the evidence should be in the form of a single joint expert, court-appointed expert, or indeed experts on both sides in circumstances where that evidence would have to be tested before this court if it was not to be sent back. Lord, our initial preference would perhaps be for a single joint expert, although we can see that the significance of the issues which are raised in this appeal might justify each party having their own expert, and those experts meeting in the normal way to seek to narrow the ambit of any disagreement and set out any agreement, and for there to be some testing of the evidence in due course.
Now, I appreciate you've not had long to formulate what you would be asking for, but what do you envisage the essential question, or if you can't envisage the precise question, anyway, the area which the IFA would be addressing, or the expert, whoever it was, would be addressing?
Yes, I think the issues which would be addressed are in relation to a PPO. Perhaps I can start with that. What the position is in relation to the availability of a mortgage or lending of the type which might be dealt with by way of a PPO, that being one of the orders, of course, that the court can make. I think it really falls into two parts in terms of how a PPO has been envisaged as operating in these sorts of cases. The first is effectively a flat rate form of PPO, where the PPO simply discharges the borrowing on an interest-only mortgage for life. I think our present understanding is that there aren't such mortgage products available. There might be, of course, if that was an order which was open to the court to make and that became a practice. Now, obviously, it's likely that that amount, the amounts which over a lifetime would be paid, even on that basis, if there was a long life expectancy, would exceed the capital sum. But that rather misses the point that PPOs, of course, come with other advantages.
I don't get too far advanced into it. I just want to know the areas that will be covered.
So that's the first area, the question of on what sort of terms and whether there would be any form of mortgage product which might be available. Yeah. The other way of looking at a PPO as a way of resolving this issue is to deal with a situation in which the claimant has in fact used capital to purchase the property, but nevertheless is going to be compensated on the basis of a PPO. And in those circumstances, one would have, under the Damages Act, to identify some form of index which was appropriate for the operation of the periodical payments order. And so that is the other area, the suitability and availability of an index.
So that's on the PPO area.
Yes.
And that is, you would say, though I think Mr. Audland would quibble about this, that is already in play. You would simply be giving or producing better and more expert evidence of material that you have already sought to put in.
Yes.
And running arguments that you already sought to argue below. Okay.
And there is perhaps one hybrid, my lord, which is that on the case which is advanced by the respondent, I'm sure you will appreciate the argument is being made that funds can be invested now and the income from the investments used to meet the claimant's needs, albeit that there will come a point at which there will need to be refinancing. I think in this case the argument is suggested to be, the point is suggested to be 80 or thereabouts in the supplemental skeleton. So at that point it might be that that refinancing could be dealt with by way of a periodical payment.
Yeah.
So that is probably the other issue which might need to be considered. The other issue relates to the choice of a rate in the Roberts and Johnston formula. Because as you will know, in the first instance Mr. Arney suggested 2%, the rate on general damages. The position when Roberts and Johnston was first proposed as a formula was that the discount rate which was used for the multiplier, which is one part of the equation, was not connected, it was disconnected in fact from the rate which was used for the investment return. Obviously the difficulty has become that once you introduce a minus figure into any formula, you get a minus.
Well, again, we understand what the point is.
Well, that's right. So the argument which might well then be addressed by further expert evidence is whether, if the court were to consider, indeed if it were open to the court to consider disconnecting the rate which was used to achieve the multiplier and the rate which was taken to be the investment return rate, what that rate would be.
Yes, okay.
So that's the other issue.
Okay, so that the application, let's just be clear about this, the application is to adduce further evidence above and beyond that which your initial, the application for the adjournment is to adduce further evidence above and beyond that which has, or which there's a current application to admit.
Yes.
And you've sketched the areas that would be covered. how long would you need the adjournment to be for?
I think it might depend upon which areas of expertise are engaged. If it was simply an IFA, we would be in a position to obtain that evidence and have the hearing of this appeal in the Michaelmas term, as your lordships indicated would be desirable.
I mean, if we were going to go down this route, it would be important that it shouldn't be half-baked.
Yes.
So that if there were areas of evidence that had not been previously explored, we might, I'm thinking aloud here, we might be looking at Hillary rather than Michaelmas. Now, what will, of course, be said, may have to say more in reply if it's said in a different way, but I think you do need to face up to the fact that although we floated this, because it seemed to us there were some advantages, the areas you now want to explore were not explored, whatever the evidence was not available or produced at trial. What do you have to say about that?
Well, the first thing perhaps is that as a matter of detail, that evidence necessarily depends on the findings which the judge reached as to contested areas and contested issues in relation to accommodation. Otherwise, it would have been an attempt to obtain evidence on what would have been a theoretical or speculative basis as to the outcome.
Yeah.
And there are also particular features of this appeal and this issue which perhaps suggest that not only would it have been difficult to canvass those issues at first instance, particularly given the case which the respondent ran and had been run in JR on Sheffield, that there was no latitude available to the court. So the threshold question was really whether the court was entitled to do anything more than apply the Robertson-Johnston formula. So in a sense, this was always a matter which was going to arise once the initial determination of the parameters of the claim had been made and the court had determined...
But the case wasn't set up in that way.
It wasn't set up in that way, no. Well, I accept that. And it may be I'm arguing from where we are now, which is that
Well, I think that's probably what you have to do. As
Yes.
I say, we probably wouldn't be making this application unless we had, I won't say invited it, but certainly it ought to be considered. So,
yes.
well, let's it's probably more realistic, now you've set out your stall, to hear Mr. Audland's opposition. You'll obviously get a chance to go into more detail on any other matters. But before you sit down, my lord or my lady, want to ask you anything further? Right. Yes, Mr. Audland, you oppose the application for an adjournment. Succinctly as you can.
My lord, yes.
Why?
May I refer your lordships to the supplementary bundle and the correspondence therein, which relates to this very issue?
No.
It's tab 9. I'd just like to refer to 5 items of correspondence relating to this application, which starts at 145, a letter of the 2nd of October. And that is a letter dealing with the Ladd Marshall application. And may I invite your lordships, first of all, to read it. The important point is that at an early stage we submitted that this application should be heard before the hearing of the appeal. And that...
Well, you say this application.
The Ladd Marshall application.
Yes.
For the
I
very
think it's
reason,
important for us, I know you're aware of this, but it's important for us to distinguish. This is a different application from the one you thought you were going to be dealing with. It's an application for an adjournment. Now, I appreciate the two are there's no degree of overlap, but we do need to distinguish, remember which we're thinking
I
about.
quite accept that, but the consequences are the same, my lord.
Yeah, no,
because
fair
the
enough.
reason why we were
Fair enough.
resisting and saying that the application should be heard first, because we were anticipating that were the application to be successful,
Yep.
the evidence would not be limited to the one letter on which the
Very well. Let's
application
let's
was
read
initially
let's read through this letter.
Thank you,
Give
my
us
lord.
give us a moment. Yes, well, speak
My
for
lord-
myself. I haven't read every word, but I've got the gist of it, and indeed, the gist of it is in your certain arguments.
Indeed. My Lord, may I take you to the claimant's response, which
Yep.
you'll find at 155, having read that letter,
Yeah.
a letter of the 7th of November.
Yes. Again, I
So,
read that.
my Lord, essentially, the nub of it is that, having drawn attention to the implications of adducing any further evidence, there having been none at all on the costs of borrowing at trial, and the wider implications of that, the claimant adopted a position that it was inappropriate to list the application first. Of course, had the claimant accepted our position, it is unlikely that Lord Justice Hamlin would have made the direction that he then did, which your Lordships will find on page 163, which was that the application should be heard at the same time as the appeal. And although I'm not proposing to take you to it to save time, there were two further letters between those two steps, the claimant's letter and the directions.
Yeah.
Letters by us repeating and reiterating reasons why it was important. And those your Lordships will find on pages 158 and 160 respectively. But I don't propose to take you to it because the essence of the point is made.
Yes. Thank you.
My Lords, if an adjournment for further evidence is required, then our position as to what expert evidence would be necessary, just so that you have that, is certainly either IFA or mortgage broker to deal with availability of products and rates available, certainly a real estate economist or someone of that expertise to give evidence both as to the costs of borrowing, the real costs of borrowing, and as to indexation. And thirdly, actuarial evidence as to inflation and the impact of inflation on borrowing costs.
I thought it was said in Aussie and National Trail Board that the evidence of actuaries on inflation was no more reliable than that of astrologers.
My Lord, you may think that I couldn't possibly comment, but in Wells and Wells, that was precisely the evidence that the House of Lords had regard to. And it's the sort of evidence, I submit, which would be axiomatic if this court is to look at all the alternative possibilities. And your Lordship has made the point quite rightly that if your Lordships go down this road, then we can't have a half-baked affair. It needs to be the case, and that case will need to involve all the evidence. Now, The reason why we resist an adjournment to adduce evidence in this form is not only for the reasons that I've set out and issues of proportionality, but this case we say is not the appropriate test case. It's not a short life expectancy case. There's no contributory negligence. And this is not a case where the claimant has opted or ever opted for PPOs for any other heads of loss. So the usual areas where it is widely accepted there are anomalies created by the Robertson-Johnson don't present themselves in this particular case. So we won't be looking at, in terms of the wider issues, the impacts of those scenarios on the wider issues, unless, of course, it was another case was joined to this case. In terms of the point that you put to Mr. Sweeting, my lord, in relation to...
Is that a hint? Are you aware of any other such case in the pipeline?
I personally I'm not.
Okay.
I think all cases have been waiting, either being settled or waiting for the outcome of this one. But I speak only for myself. In terms of Mr. Sweeting's point that the evidence couldn't have been obtained at trial, it would have been obtained on a theoretical basis, or I've made the point in the skeletons, I'm not going to reiterate it at length, but your lordships have the point. The problem with the appellant's argument there is that the appellant themselves advanced their case in the schedule on the basis that such expert evidence, not just a mortgage offer, was necessary and would be obtained if we didn't agree mortgage rates, which we never did. So the position now being adopted on behalf of the appellant is rather inconsistent with the position advanced all the way to trial.
And am I right in thinking that another point you make in your skeleton argument is, perhaps this wouldn't apply to all the arguments being sought to be advanced, but some at least, you do not need to know the precise figures. The evidence to be done on the basis of notional figures, you establish a methodology and the rest of it, and then that can be fine-tuned when we know what the judge actually awards.
Absolutely.
Have I got that? I picked that up correctly.
You have precisely. I accept, in fairness, that there are some areas of our illustration which would be assisted in an ideal world with additional expert evidence, but that only effectively illustrates the point that we're only here because of the appellant's failure to adduce any evidence at trial on this point at all. So, for example, your lordship, as to how the money could be borrowed from AT if and when it is borrowed, the claimant advances only one possibility, that's an interest-only mortgage, but there are others, and those include equity drawdown and set-off mortgages, which are far cheaper. Now, you have no evidence before you because we are where we are, but those are areas where I certainly accept that we would be in difficulty, albeit we can deal with the matter mathematically on certain assumptions.
Yeah.
My lord, as to, if you're against me on all of that, what I say is there is a serious question as to how we move this forward with an adjournment, because in the usual way, this evidence will be so important that it will have to be tested. And as your lordships will bear in mind, people's position all along, from the first skeleton argument to Mr. Allen's skeleton argument, in which he stands by the first skeleton argument, a test case is necessary to analyse borrowing costs. Now that imports with it, by necessity, envisaging expert evidence on both sides, which will be challenged, because how are the parties going to test evidence that's simply adduced before your lordships? So we say that if you are in favour, and we quite acknowledge the wider implications and the importance of this case, if you are nonetheless in favour of adjourning, then the appropriate evidence, the parties should have the opportunity to get party evidence, and the appropriate way forward would be some form of trial, either by remitting that. It would be most...
We can't, I think, procedurally, we can't remit it unless we allow the appeal.
Or by adducing evidence in some form and allowing that evidence to be tested before this court.
Yeah, well, I think that's what, I haven't examined this procedurally. There may be a procedural route of which I'm not
And
aware.
I
think
haven't-
we can hear evidence, it's just very unusual.
Certainly, and I haven't had the time to research that.
No, I understand that.
I'm in uncharted waters myself. But your lordship will also bear in mind that well, no, I'll leave.
No,
I'll leave that
we
point.
have, I think, big, yeah, that's very, I mean, I think the thought that goes through my mind, really, in case Mr. Speaker was thinking about it, is, in a sense, his own point that judges below have felt shackled by Roberts and Johnston. If we were to proceed with this on the basis of the evidence that's available, it would be open to us to say this is what we have to do on the basis of the evidence available and the points that can be raised on that evidence, but it's suboptimal. And that next time one of these cases comes up below, if this is our view, first instance judges should not feel as hobbled by Roberts and Johnston and should hear the kind of evidence that will be needed if this was already to be re-examined, even if in the end they feel that they can't themselves overturn Roberts and Johnston. In other words, there would be a test case which was fully examined at first instance and then came to us. That's the implication, I think, of the point you're making.
Absolutely. And all we say is that this case is probably not the best case to turn
You
into a
made that
test
point
case.
you've made. Thank you. Is there anything else you want to add?
No, man.
Mr. Sweeting.
Well, it's probably important to bear in mind that the way the case was conducted at first instance was driven by the fact that with a life multiplier of 55, virtually all of the other options which could conceivably be canvassed, and they were options which had been set out in many articles and referred to by PIBA itself and so on over the years, resulted in a sum which exceeded the capital sum. And so it was entirely logical from a learned friend, Mr. Arney, to advance the case in the way in which he did. I think the concern which, in fact it's right to call it concern, your lordship's articulated this morning, ladyship as well.
I should say none of this is in any way a criticism of the way it was done, but
Yes.
But you can understand why we need to test whether this is an
Yes.
appropriate case for
Yes.
a wider consideration. And the fact that you are applying to make, applying in any event to adduce further evidence triggered this whole question in our minds. But it doesn't necessarily follow this is how it ought to be done below. So
No.
you needn't worry about that.
No, well, Lord Dunn, I appreciate the application in itself for a limited amount of fresh evidence, maybe the hook upon which at least the provisional view which your lordship was advancing this morning was hung. Lord, the answer really, I think, is that if the court does want to, for very good reasons, because of the position we're in at the moment, which is an impasse in relation to what is likely to happen at first instance, because in the real world, claimants will have to get permission to use expert evidence and will want to do so in a forum in which that is not fruitless, because it's simply going to be met with the answer that it's all irrelevant. It's more or less what the judge said in this case, although she was in a difficult position plainly. And it's obviously not going to be likely that claimants will get permission to adduce evidence simply to assist them on an appeal. Now, this case is in front of this court. There is very rarely a perfect case in which to decide these issues, but this is one in which the issues plainly arise, and its scope can clearly be broadened to encompass points of principle which would bear on different cases of short life expectancy, or where there has been some deduction for contributory negligence or for the purpose of a settlement. Indeed, those are things which would have been touched upon in the arguments on either side, because they go to the question of the viability of the present approach under Roberts and Johnston. And Lord, I just noted that when Lord Justice Jackson was approving the settlement in JR and Sheffield, one of the things he said was that it's clear that sooner or later this court is going to have to grapple with Roberts and Johnston in the new world. And my lord, my lady, we are in the new world, and this is a matter which needs to be addressed, because it not only has implications for claimants when they get to trial, it has very significant implications for claimants who are seeking interim payments of damages as well. And the purpose of those is often the threshold question before therapy and everything else can be addressed.
Is this a fair summary of your submissions? And if it is, entirely realistic. You, as it were, take on the chin the various points Mr. Ordland makes, but say that they are outweighed by the value, not only the advantage to your client, but also the broader value of having a test case now rather than one that's hobbled, as it might be if you weren't allowed, certainly if you weren't allowed to obtain further evidence, and even less if you weren't allowed to rely on the evidence you've already obtained.
Yes. Precisely.
Well, but that's a perfectly sensible, broad position. You can't answer, or can you, any of the detail points he's made, which he's only made quite succinctly about the correspondence and so on. If you have points to make about them, you better tell us what they are.
Lord, I don't have any points to make about them. I was simply hoping to explain by the very first point I made why that stance was taken, and it was a logical one in the context of the appeal.
Yes. Well, again, I mean, just to spell this, he must be right, mustn't he, that at least possibly, we need to say how great the probability is, any expert evidence relied on might have to be tested by cross-examination.
Yes, Lord.
What would your proposal be as to how would you say that, if necessary, would have to be done most exceptionally in this court?
Yes.
Right.
I think that's inevitable unless one was to go down the route of court-appointed or single joint expert. And I think, as I conceded in making the application, that might be a difficult course to take in a case of this importance for the very reasons I've just articulated.
Well, speaking of the risk might be that the fight is transferred as to which expert to choose for joint instructions.
Yes.
Then in the course of the instruction, differences emerge, and one party or the other doesn't like the answer they've got in the course of that process. And then there's an application to introduce somebody else. So one can see the difficulties with that. While you've been addressing us, I looked at CPR, it's in the White Book at page 1818, the admission of fresh evidence. The power to admit is very broad, it's 52 spot 21 brackets 2. And all it says is unless court orders otherwise, the court will not receive oral evidence or evidence which is not before the lower court. So this court can order otherwise, and the notes don't suggest there's any. While the normal approach is to allow the martial approach to have carried over, once you depart from that, there isn't any ostensible limit in what can be brought in.
No.
And one would have thought, if there is to be an adjournment, the sensible thing is to make sure that both sides are content that what they need is before the court.
Yes.
I thought that must be right from everybody's point of view.
Yes.
Mr. Allen, I don't think you have any locus on this. If there was something you were bursting to say.
Not bursting, my lord, no.
No. Well, we'll rise and decide where we are. Thank you.
That's all right.
Not very skiing.
Cancel it now. Sorry.
The red light's still on.
ready. Court rise.
Well, there are good points to be made on both sides of the application, and we have thought about them carefully outside, but we have come to the conclusion that the balance does come down in favour of an adjournment. What we propose is that there will be a short further discussion about the scope of the issues to be reviewed, but that we will then give council the opportunity to take further instructions and come up with a more detailed proposal for a timetable and for directions, and the matter will come back tomorrow for discussion, whether at 10:30 or at 2 o'clock, but certainly tomorrow, in front of my Lord Justice Irwin, who will be responsible for the case management of the appeal, and it may well be that the parties can agree directions. If they can't, he will make them. It is important that the case come back as soon as possible, but given the scope of the issues that may be an issue, it seems to us prudent to look at the Hillary term, but no later. And it seems to us prudent, I hope this won't be necessary, but prudent to have a 3-day listing. But one of the things that council should be considering when we rise is dates that they can do in the Hillary term for 3 days. We will inform the listing office, and they will be as cooperative as they can be. As I've said, fortunately, the state of the Court of Appeal list is not as dense as it has been in the last few years. So I suspect it shouldn't be difficult to find a date. That seems to us to be the way forward, but before we rise, as I've just said, I think it would be useful if there are any general points beyond those which have already been raised, which it's useful to say more about at this stage. It may not be, for as far as council are concerned, but I know my Lord Justice Irwin, it may be myself also, and Lady Justice Nicola Davies, would just like to raise feed one or two thoughts into where we're going. I'll ask my Lord first.
Mr. Sweeting, one of the curiosities reading the submissions thus far is that almost any of the options advanced by the appellant costs the respondent more than the capital award.
Yes.
And that it does mean that there are interests on both sides that require to be reconciled. Can we just for a moment stand back and think about first principles? The reasonable requirement here, said the judge, was that the appellant should be able to acquire the additional home. That requires access to £900,000 for life. One might say for life plus 1 year, so that the estate can wind up the affairs of the estate. Some of those who thought carefully about this whole issue, including the editors of McGregor, have floated the idea of a trust. And if one looks at the need here in property law terms, it would be apt to describe what is needed as a life interest in £900,000 life interest plus a year. But the evil that that has always brought is the windfall. These are fundamentals and you'll all know them, but let's try and think through what they might mean. In property terms, the windfall could be described as the reversionary interest in the capital, additional capital. If one could achieve that result, then there might be an argument, and that's what McGregor suggests, that that avoids the injustice of a nil award on the one hand, and the injustice of a windfall on the other. Reversionary interests, setting aside this context, can be sold. There is a potential market, an actual market in them. And it struck me, considering the submissions and reading what's been said by the commentators, that selling the reversion in this context, in this case or any case, should be easier than in a normal family trust context, precisely because the term of life interest has been the subject of contested expert evidence and an adjudication. So the period is already established. Now, if a market price value of the reversion can be reached, then various possibilities arise, if that's right. Firstly, the claimant might choose to purchase that reversion. Why does that help? It avoids all of the complexity, particularly over a long life, that might well arise from the respondent, the defendant, or the insurers of the defendant, guarding the asset over 40 years, 50 years. In the context of your existing argument for a capital award on the facts of this case, and those arguments might be applied in many others, not all, short life might be different, then a pragmatic solution, to borrow a hallowed phrase in this context, might be for the court to say, well, if that claim for a capital award is valid, but we need to avoid the windfall, which is an injustice to the defendants, then perhaps the Robertson-Johnson approach should be taken to the value of the reversion, so that what is really needed is provided, the reversion is quantified, the windfall avoided, and all in the context of a capital award, plus something like Robertson-Johnson reflecting the relevant rate of return on capital. There's an elegance about that. It would be terrible to enter into the hearing we are anticipating without making sure that that and all options aren't addressed, because that then leaves not only these parties but future parties thinking, well, what if we had explored that? Not only is such a solution, and I speak hugely provisionally here, you will all understand,
Yes.
not only has it a simplicity and an elegance, but it seems potentially to meet the needs of the claimant and to do so with finality. But it also is hugely cheaper for the insurer in this case and in many others. Hugely cheaper than some of the models of cost. And those costs might be reduced by some of the expert debates which are sophisticated. But all of those expert debates turn on anticipating complex future events which are highly uncertain. If there is a market valuation of the windfall, if I can put it that way, then that's a much simpler solution, potentially. And it simply takes what those who edit McGregor 2 or 3 steps farther with a little bit of expert evidence to address it. Now, I throw that out now so that before the directions hearing tomorrow, that at least is included for both sides to think about. I wouldn't want anybody, including Claimant, to misunderstand that this is merely an attempt to make sure we do capture everything that needs to be captured. No more than that.
Well, perhaps just so I've understood it, and I may not have done, is what your lordship is postulating a valuation of the reversionary interest, which is then used to make an adjustment to the capital sum.
Yes. Because if the evil of a capital award is the windfall, then you separate conceptually what is needed and is not an evil from the windfall. And you then deal with the windfall either by creating a trust arrangement. You don't need tax consequences of a company, you don't need a company. And in some cases the trust arrangement might be more apt, because if you have a claimant who's under a disability and where there's a trustees anyway and where there's a relatively short life expectancy, then that solves the problem one way. But in such a case as this, if you can value the reversion properly at a market basis or a respectable basis, then either there would be an argument to simply deduct that from a capital award, or there might be an argument that you treat the value of the reversion as something that a claimant can purchase, where the claimant chooses to purchase it from, that's for the claimant. Or you might argue that that should be treated subject to a Robertson-Johnson type approach, because the Robertson-Johnson solution becomes apt in two ways. One, it doesn't consume huge quantities of damages that otherwise are needed for other purposes. Two, it reflects the historic approach the courts have taken to forced investment of damages awarded for other purposes. One of your arguments in this case being this is forced investment of damages that were awarded for specific purposes on an assumption as to return of money, and so on and so forth. So I don't want to overcomplicate it now, but it seemed to me that was an avenue posited by others with a little bit of development might serve both parties properly on the facts of this case and on others. So
No, I think I follow. I mean, the reversionary interest obviously would result in the property at the end of the claimant's life reverting to the defendant.
Well, if the reversionary interest stays in the hands of the insurer or the
Yes.
insurer's successors and title.
Yes.
If, on the other hand, there's a purchase of the reversionary interest, then that makes it simple for the claimant. And then the argument would be, well, is that a voluntary purchase, or is it something the courts should simply accommodate by making a capital award for what is not a windfall, and then a Robertson-Johnson type award, or simply declining to make any award in relation to the windfall, so that the claimant gets what is not the windfall as a capital sum, as you would argue, but gets nothing in respect of the reversion, because in the end the estate will get it. There are many ways of coming at that, but all of them have the potential for a final award which is fair to both sides, or fairer than either no award when the judge has ruled there needs to be £900,000 awarded, or a solution which costs the insurer more than awarding £900,000. Each of which is a relatively unattractive solution to a problem.
Not required, Mr. Sweeting. It's been helpful, I'm sure, for you to explore what my lord was putting to you, but beyond that, you're not required to immediately mark it out of 10.
No.
But it's the important,
I'm resisting.
I will never ask you to mark it out.
the consequence of the route we have taken is that, despite Mr. Audland's protestations, we do want this to be, quotes, the case.
Yes.
And that does mean, with the assistance of PIBA, which we hope will continue, seeing that all options are considered. They are all potentially relevant to your client's claim. It's not, we're not asking you to write essays which won't ever affect your client. They're all potentially relevant. But points that were not fully considered, partly because it was thought they weren't really open. I think we do want the court to be fully informed about all options, and my lord has suggested one which is there, in fact, in the commentators, but hasn't been very much focused on up to now. There may be others which the fertility of those behind you or yourself will produce. We don't want there to be an absurd academic exercise, but we do want to cover all the options, and that's why we're giving you a bit more time than you initially asked for. I haven't, I'm afraid, a fully worked out or even half worked out proposal to put alongside my lord's. I don't think my lady has either.
Not as I'm not going to come up with another proposal, so no more marks out of 10. Thank you.
But can I just say in relation to that, I think from our side, the only constraint that we have ever identified really is something which the court can actually order.
Yes.
As opposed to schemes, if I can put it like that, which might be dealt with as part of a duty to mitigate, perhaps, but are not something which it's in the gift of the court to impose on the parties. I mean, the example of a loan springs to mind. Obviously, mitigation is a matter of fact. The bar is pretty low, in fact, in terms of what's reasonable for a claimant to do or not to do. But those sorts of options are options which don't, in fact, align with powers which the court has. I think, with respect, the suggestion we've just had could be made to align, but there are a number of others which have been considered by the commentators which simply wouldn't arise on the court's exercise of its powers.
I meant what I said. If there are things which really can only be done with legislation,
Yes.
then perhaps ideally a paragraph saying that's why this isn't being pursued will, I'm sure, be helpful. But
Yes.
You're quite upset that pursuing things that would be ideal but can't be done is not a useful use of anyone's time or costs. Now, we will, of course, give any further guidance that the parties think useful at this stage, but what I hope and expect is that we've reached a point where you can all go away and think, firstly among yourselves and then between each other, and can come back, as I say, tomorrow, hopefully with some agreed directions, or at least with identified areas of dispute as to what the directions are. I think my lord is relaxed as to whether it's 10:30 or 2, but I think it needs to be tomorrow so that we have some certainty as to how we're going forward.
I would suggest it might make sense to make it 2 or 2:15, but to indicate that agreed draft directions, so far as possible, and contested where not, are with me by, say, 11:30.
Well, yes.
That gives you the most time. It uses the window, and it means I know where I am before coming in at 2:15. But if you say, no, you'd rather be here at 10:30, then you'll have to give me something to read overnight.
Well, it sounds sensible to be back in front of your lordship tomorrow afternoon.
Inducement.
I think your lordship was making me an offer we couldn't refuse. But,
Yeah, we're looking at you. Of course, the same applies to Mr. Ordland, and I suspect Mr. Allen won't be involved in this part of the process. There can
Well,
be if the parties let him.
I was only going to rise, my lord, to raise two things. First of all, one, to ask to be excused from tomorrow. This is a debate between the parties, and we wouldn't wish to complicate that in any way. But to simply flag one reservation, which is, it is an unusual course for this court to receive such evidence, and we do not intend to complicate that. But in the event that there were to be a view that there was a gap within the evidence, it might be that we would make such application to my Lord Justice Irwin, designated as the case managing Lord Justice for this exercise. But I reassure my lords and my lady, that's not intention, that's just flagging something out of an abundance of caution.
Yeah, that seems very, very sensible, as you rightly say. I think it will be looked at sceptically, but not if it's really a good case for it. I'm sure it'll be taken on board.
Thank you, my lord.
Right. Well, then from myself and my lady, that's we'll see you in the Hillary term. You'll see my lord tomorrow.
My Lord, may I just
Yes.
raise one matter? Nothing has been said about costs, save by way of mention only, but I'm assuming that your lordships will reserve all the costs implications of the order that's
That
been
was
made.
certainly our intention. And actually that reminds me of one pathetic point on which to end, but just to get off my chest. In almost every way this case was well prepared. We found the charlatans very helpful. One thing we did not find at all helpful was the bundle of authorities, which had been put together on a system I'd never seen before by alphabetical order of case name, or indeed if it was a Law Commission report, it came in under L. And sitting down as I intended to do to remind myself that the case is starting at the beginning and we're at the end, it became more and more annoying. So I've got that off my chest, but lessons learned. There are many sensible ways of doing bundles of authorities, but this wasn't one of them.
My Lord, we ourselves had, we accept that. I've spoken to Mr. Sweeting about that this morning and apologise. Your Lordships will appreciate that due to extended deadlines, there was rather a lot to do last week and there was a certain amount of activity required on all fronts. So I do apologise, but that would be
Apology
remedied
accepted, no more
next time round.
Next time round. Right. Oh, well, one moment. Yes, that's a very fair point. We believe, we may have got this wrong, that the claimant herself is in court. I just would like to say this on behalf of the court, that I'm sure she would have been coming here hoping to bring this quite long-running saga to an end. Not obviously she would have been told the day or tomorrow, but at least to get within distance of it, and now she's going to have to wait many more months. We are not unalive to that, but it is frankly in her own interests, as well as if she thinks she's just been used as a test case for the greater good. It's also, I think, in her own interest that this issue be very fully explored. But I wouldn't want her to think we aren't aware of the human side of all this. We very much are. But this, I'm sure, is the best route in the long run.
Well, thank you for that. I did have the opportunity to speak to her during the adjournment,
Yes.
and she fully understands why the question of adjournment was canvassed and why we've made the application. It was with her support.
No one likes being wrapped up in a test case. I'm afraid it does sometimes happen, and as I'm repeating myself, it will have advantages for her as well as for everyone else.
Yes.
Thank you.
Solutions of the legislation. The more issues we try and
One of those times